Hey there, I'm the Madcatster. Am I glad to see you here? Well, Ethan Klein and his wife Hila have been talked about a lot on social media lately about some stuff to do with their children and some really bad things that someone did to get them into trouble with CPS and really disgusting. But there's also something else that's been going on. That is, one of their maids filed a lawsuit against them, accusing them of unlawful termination and saying that they discriminated against her. You know me, I've got the deets and all the receipts, so buckle up and let's go. So I'm here tonight. I'm here with Antoinette and her rival, Sybil the Enforcer. Antoinette and Sybil are kind of like friendly rivals. They don't like each other to steal the other's spotlight, so they're right now jockeying for my affection. You can see Antoinette is giving Sybil a little bit of a hard time, but Sybil can hold her own, believe me. And Sybil says, please like and subscribe. We'd really appreciate it. And if you think you're subscribed, double check, because again, I've had people telling me that they went and looked and noticed that they were not subscribed anymore for some reason. So if you would please check, and if you're not subscribed, please subscribe. We'd really appreciate it. Sybil would really appreciate it. If you can hear her purring away. So anyways, Ethan Klein and his wife Hila, one of their maids, has filed a lawsuit against them in court in Los Angeles, and she's accusing them of not granting her a reasonable accommodation, and we'll get into what that means in a few minutes, and unlawfully terminating her and saying that it was discrimination and, that the firing was in retaliation. I deal with cases like this on a regular basis, although the ones I deal with are in housing discrimination. Reasonable accommodations are basically the same issue in either arena, so I'm pretty familiar with how these things go, and I can tell you that in general we win like 95 to 99% of them because there's usually no basis really. And we're going to talk about that in a minute. So let's take a look now at the lawsuit that she's filed, and then we'll talk about whether it's got any merit or not, in my opinion. So you can see here, it's the Superior Court of the state of California in Los Angeles, and it's Elizabeth Borda versus Teddy Fresh, which is Ethan and Hila's company, the clothing company. Hila Klein, an individual, Ethan Klein, an individual, and does 1 through 20 inclusive. And again, we've talked about this. They are anticipating there may be more defendants, but they just don't know their identities yet. And so if they do come across someone who should be a part of this lawsuit as a defendant, they will then ask the court to add them as one of the does. And anyway, so this is her complaint. Complaint for damages, violation of the California Family Rights Act, disability discrimination, retaliation in violation, failure to provide reasonable accommodation, failure to engage in interactive process, failure to take reasonable steps to prevent discrimination, retaliation in violation of California paid sick leave law, wrongful termination in violation of public policy, failure to provide meal and rest periods, failure to pay overtime, failure to pay state and local minimum wage, failure to pay all wages due, and failure to furnish wage statements. And then it goes on, there's waiting time penalties, failure to provide personnel records, and unfair competition in violation of business and professional code. She demands a jury trial, which usually they do. And this is what she alleges. So it's quite a list of things that she's got going on. So let's find out exactly what happened. So on information and belief, at all relevant times, defendant Teddy Fresh Inc., TFI, was a California corporation doing business in California. On information and belief, TFI is and was at all times relevant, owned and operated by defendants Hila Klein and Ethan Klein, collectively the Kleins, each of whom at all times was an officer, director, and or managing agent of TFI, and another person acting on behalf of an employer within the meaning of Labor Code Section 558.1. On information and belief, there is unity of interest between defendants in each of them, and each acts as the alter ego of the other, and failure to recognize the alter ego relationship would lead to an inequitable result. So basically what she's saying is that there's them as people and there's the company, but that they're basically one and the same, is basically what she's saying. So that they shouldn't be separated out as individuals and company in terms of like separate lawsuits. On information and belief, the Kleins and TFI are and were engaged in one or more of the following: commingled funds and other assets, which means like having your business assets as part of your regular like checking account, say like the money from the business going into your personal account. Failed to segregate the funds of the separate entities, engage in the unauthorized diversion of corporate funds or assets to other than corporate uses. treated assets of the corporations as though they were individual assets, such as by paying personal debts with corporate funds or utilizing corporate funds to purchase assets for individual shareholders with no discernible benefit to the other stakeholders. Failed to obtain proper authority to issue all stock granted to certain shareholders. The first thing I'm thinking is, how is this relevant to her claim about her employment? I mean, even if what she's alleging is true, I don't see the nexus with her claim that they fired her illegally and discriminated against her. Failed to obtain proper authority to issue all stock granted to certain shareholders, allowed one or more individuals to state that he/she will be personally liable for the debts of the corporation. Failed to follow corporate technicalities such as maintaining proper records, holding regular board. See, and again, like all of these things, I didn't read anything in the counts where she's suing them because of some business practice that was untoward. She's suing them because of monetary damage she claims she sustained from that. Failed to follow corporate technicalities such as maintaining proper records, holding regular board and shareholder meetings, and properly electing officers to craft and administer corporate policy. Shared owners, directors, and officers with other related or closely held entities. Shared office space or business locations with other related or closely held entities. Employed the same attorneys for more than one related or closely held entity. Failed to adequately capitalize a corporation, including potentially failing to have any equity, corporate assets, and or undercapitalization of one or more related or closely held entity, used one or more of the defendant entities as a shell or instrument for the benefit of a single overarching business venture, such as by using a corporation to enter into contracts that benefit the owner of another related or closely held corporation with no discernible benefit to the other shareholders of the entity being exploited thereby, concealed or misrepresented the identity of the responsible ownership, management, and financially interested parties of one or more of the defendant entities, used one or more of the defendant entities to procure labor, services, and or merchandise for another person or entity, diverted the assets from one or more of the defendant entities by or to a stockholder or by other person or entity to the detriment of and or defraud creditors, including but not limited to recapitalization of assets under a different corporate form or moniker, manipulated the assets and liabilities between the defendant entities, such as to concentrate the assets in one or more of them while concentrating the liabilities in one or more of the others, contracted with third parties with the intent to avoid performance by use of the corporate entity as a shield against liability, used one or more of the defendant entities as a subterfuge of illegal transactions, and or formed and used one or more of the defendant entities to transfer an existing liability to another person or entity. This is quite an opening. This is like something I would expect to see like from a shareholder, like what they call a derivative lawsuit, or, you know, some other interested corporate person suing a corporation for wrongdoing or for nefarious activities. So I'm kind of taken aback by all of these allegations about the business being set out at the very beginning of the facts section. So I'm interested to see where they're going with this. At all relevant times, plaintiff was jointly employed by defendants who shared authority over and control of the terms and condition of the plaintiff's employment. The true names and capacities, whether individual, corporate, associate, or otherwise, of defendants designated herein as those 1 through 20 inclusive, are unknown to plaintiff, who therefore sues such defendants by such fictitious names. Plaintiff will amend this complaint to show their true names and capacities when the same have been ascertained. Plaintiff is informed and believes, and thereon alleges, that each of the defendants designated herein as a doe was in some manner responsible for the occurrences and injuries alleged herein. Plaintiff is informed and believes, and based thereon alleges, that at all times relevant herein, each defendant was acting as an agent, joint venture, or as an integrated enterprise and or alter ego for each of the other defendants, and each was a co-conspirator with respect to the acts and the wrongful conduct alleged herein, so that each is responsible for the acts of the other in connection with the conspiracy and in proximate connection with the other defendants. Plaintiff is informed and believes, and based thereon alleges, that each of the defendants was an agent, managing general partner, managing member, owner, co-owner, partner, employee, and or representative of each of the defendants, and was at all times material hereto, acting within the purpose and scope of such agency, employment, contract, or representation. Each of them are jointly and severally liable to plaintiff for the acts alleged herein. Plaintiff is informed and believes and based thereon alleges that each of the named defendants aided and abetted, encouraged, and rendered substantial assistance to the other defendants in breaching their obligation to plaintiff as alleged herein. In taking action as alleged herein to aid and abet and substantially assist the commission of these wrongful acts and other wrongdoing complained of, each of the defendants acted with an awareness of his, her primary wrongdoing and realized that his conduct would substantially assist the accomplishment of the wrongful conduct, wrongful goals, and wrongdoing. Defendants in each of them also knowingly and willfully conspired to do the acts and things herein alleged pursuant to and in furtherance of the conspiracy. This is quite a convoluted and loaded complaint. Plaintiff served as the full-time... Okay, now we finally get to, like, the facts that are, like, relevant to why she's brought this lawsuit. Plaintiff served as the full-time personal housekeeper to the Kleins, beginning on approximately December 16, 2020. She was well regarded during her time with them and fulfilled her job duties without issue, including cleaning the house, doing laundry, making meals, regularly performing errands, and grocery shopping. During her employment, plaintiff suffered from a hernia, of which the Kleins were aware. Okay, so this is where the reasonable accommodation is coming in, I'm guessing. On June 18, 2024, plaintiff learned that she would need surgery for her hernia. The very next day, June 19, 2024 at 10 a.m., she notified Mrs. Klein that she would be needing time off for hernia surgery beginning on July 19, 2024. So 30 days later, so that's reasonable notice. And that her doctor expected she would need a month to recuperate. Shortly thereafter, on June 20th, only 2 days after plaintiff notified her employer that she needed time off for hernia surgery, Carrie Bish, EDP of Finance, called plaintiff to notify her that her employment was being terminated and that she did not need to return to the house. Days later, as Miss Bish attempted to have plaintiff sign a release, which plaintiff declined to sign, plaintiff pressed for a reason for her termination. Ms. Bish responded that her employer was going in a different direction and referenced a problem she had with the Klein's nanny. The reason was pretextual. In other words, they're saying they made up a reason just to get rid of her. Defendants terminated plaintiff because she requested time off for her hernia surgery. Okay, so I don't know all of the facts, of course. I only know what the maid is saying. Something about that doesn't seem right to me. Like, say what you want about Ethan and Hila. I mean, they seem like pretty, like, decent people in terms of, you know, like their interactions with their staff and stuff. I've never seen any indication that, you know, that they're like mean or nasty people. So right away, this is like a red flag to me. I'm like, okay, so they fired her because she asked for time off to get hernia surgery? That doesn't sound right to me. So we'll have to wait and see as the, you know, discovery process goes and what the Klein's answer says, especially, but also like what she produces to back this stuff up. So I'll be interested to see how they answer this. Of course, it's probably just going to be a general denial, but we'll see. Maybe they'll give us a little more information, shed a little more light onto the situation from their perspective. Anyways, right now, to me, this sounds a little, okay, that sounds a little extreme. So anyways, that's just my intuition. Plaintiff has exhausted her administrative remedies by filing a charge with and receiving a right to sue letter from the California Civil Rights Department. Now, that's not as big a deal as it sounds. You file a complaint with a anti-discrimination agency, like a state agency usually, and they will then open an investigation. Then they will make a determination. So I don't know whether they actually investigated and then decided that they weren't going to pursue this, which wouldn't be helpful to the maid. But then what they do is they tell you still have the right to sue in civil court. That the fact that you went to them and filed a complaint, even if they don't find any probable cause for the discrimination, you still have a right to then go to civil court and file a lawsuit on your own if you so choose. So that's what a right to sue letter is. So it's not like, it's like pretty routine. It sounds more ominous than it really is. First cause of action, violation of the California Family Rights Act. Plaintiff is a member of the class of persons entitled to protected medical and or family leave under the California Family Rights Act. Specifically, plaintiff worked for more than 1 year for defendant and worked in excess of 1,250 hours in the preceding 12-month period prior to her requested medical leave. Further, plaintiff had a qualifying serious health condition, a hernia, for which she needed surgery. Defendants in each of them violated the California Family Rights Act by refusing to provide plaintiff the medical leave to which she was entitled and by retaliating against plaintiff for exercising her right to medical leave for her serious health condition. In engaging in the aforementioned conduct, defendants in each of them aided, abetted, incited, compelled, and or coerced unlawful employment practices in violation of the announced policy of this state against such practices. Plaintiff is informed and believes and thereon alleges that a substantial motivating factor for her termination was the fact that plaintiff exercised her statutory employment rights under the California Family Rights Act. Defendant's decision to terminate plaintiff violated the government code. You would have to be pretty dumb to fire an employee who's asking for time off for a legitimate, and presumably she provided some kind of verification of this to them, for some kind of surgery, and say, well, this is a good time to fire her before she goes out on leave. That just, I mean, I'm not saying that that didn't happen. I'm just saying that that just, to me, sounds pretty dumb. So make of it what you will. I mean, I go into everything with a healthy dose of skepticism, so we'll see. Second cause of action, disability discrimination in violation of the Fair Employment Housing Act. And I took a look at this act because the state discrimination agency oversees any complaints coming about violations of this act or alleged violations. Pursuant to government code, employers may not terminate employees or discriminate against employees in the terms, conditions, or privileges of employment because of an actual or perceived disability. One thing I just want to say about that, generally a disability is, at least the ones that I deal with, it's either a mental disability or it's a physical disability. It's some kind of ongoing disability that affects your ability to function in society the way most people do. And so generally you ask for a reasonable accommodation because you need either the housing development you live in or your employer, whoever, you need them to make some kind of a change to their policies and procedures that will better enable you to participate and to do your job or enjoy your residential community better. Generally, it's not anything terribly overbearing. A hernia, I mean, that's like a temporary thing. So I'm not saying it doesn't qualify. I don't know enough about California's laws, but to me, a hernia, that's a medical condition. That's not something that you need a reasonable accommodation for, especially as she sounds like she was diagnosed and she informed them after she was diagnosed and that they told her right away she was going to need surgery. So it's not like this, doesn't sound like this was like an ongoing thing. So to find out, like, say I found out that, I have carpal tunnel and I need to go in and get surgery for that. I mean, that's not in itself, in my opinion, is not a disability. It's a medical condition that's correctable. Maybe after the surgery, I need some kind of reasonable accommodation because my hand isn't functioning quite as well as it would have had I not had the carpal tunnel surgery. Then you might need a reasonable accommodation for your ongoing ability to do your job. This to me is not a disability the way I understand disabilities to be. I'm not saying she's not right because I don't know all the ins and outs of California law, but that to me is that sounds like this is a mischaracterization, in my opinion. At all relevant times, defendants in each of them were aware of plaintiff's disability and or regarded plaintiff as suffering from disability. Defendants discriminated against plaintiff because of her disability, including by terminating her because of her disability. In engaging in the aforementioned conduct, defendants in each of them aided, abetted, incited, compelled, and or coerced unlawful employment practices in violation of the announced policy of this state against such practices. Now, I just want to look up and see if I can find something that would tell me whether or not a hernia is considered a disability in California. Okay, so I took a look. This is what I found, and this is kind of the way my thinking was going. While a hernia itself isn't automatically a disability, it is if it significantly limits your ability to work due to pain, limitations, or medical conditions, it can qualify you for disability benefits in California. Basically, from the level of Social Security, this is what I found. A hernia alone is not enough to qualify you for disability benefits because most can surgically be repaired. However, when hernias are seen along with other serious medical conditions and when they cause severe complications, they can be part of what qualifies you medically for Social Security disability. She doesn't allege that this was something she had been dealing with for a long time. So again, it sounds to me like it came up, she got diagnosed, they scheduled her for surgery, she informed the Kleins that she had a hernia and was going to need surgery, and that she would need time off starting from the date of the surgery and then a month after that. The surgery wasn't going to be for another 30 days from when she notified them. So asking for time off for the surgery to me doesn't sound like what we would consider to be a reasonable accommodation. That's more like I need time off under, family medical leave or under, sick leave or whatever. But it doesn't sound to me like it's a disability in the way that I understand disabilities to be in the work I do, in that she wasn't asking for an accommodation to help her do her job. Like, she didn't say, oh, I can't lift any heavy laundry baskets, or I can't lift the children, or, there are certain things I'm not going to be able to do because of my hernia. I need you to give me a reasonable accommodation so that I can avoid doing those things that are going to exacerbate my injury. Therefore, I'm requesting a reasonable accommodation. That to me would be an appropriate reasonable accommodation. I don't think alleging that just the fact that she got diagnosed with a hernia meant she had a disability. And it sounds to me like the state probably wouldn't either think that that was a disability. So anyways, that's my 2 cents, in my opinion. Third cause of action, retaliation in violation of the Fair Employment Housing Act. Pursuant to the code, employers may not retaliate against any person opposing any practices forbidden by the Fair Employment Housing Act. Plaintiff requested defendants to reasonably accommodate her disability, including by giving her time off to have surgery and recover. In retaliation for plaintiff's request of reasonable accommodation, defendants in each of them subjected her to adverse employment action, including but not limited to terminating her employment. In engaging in the aforementioned conduct, defendants in each of them aided, abetted, incited, compelled, and or coerced unlawful employment practices in violation of the announced policy of this state against such practices. Usually when you ask for reasonable accommodation, I know like with HUD, you can do it verbally. It doesn't have to be in writing. But a lot of times the employer or the housing agency or development will ask that a doctor verify the disability. In my experience in the discrimination complaints I deal with, it does not have to be a written request for a reasonable accommodation. You can make a verbal request. However, usually there's a process. And what happens is it's called an interactive process begins between the parties. And usually what will happen is the entity that is being asked to give a reasonable accommodation will ask for some kind of doctor or medical verification of the disability and, showing that there's a nexus between what they're asking to be accommodated and their disability. So there has to be a nexus between the two. The maid doesn't allege here anywhere that she actually provided them with a doctor's note or that she made a formal request for reasonable accommodation. It sounds like she just asked for time off to get surgery, which, normally you would do if you had a surgery like that coming up. You wouldn't ask for a reasonable accommodation. And she doesn't say she asked for a reasonable accommodation. She says, I believe, just that she told them she would need time off and she would need time off to recuperate. Fourth cause of action, failure to reasonably accommodate disability. Pursuant to government code, it is unlawful for an employer to fail to make reasonable accommodation for the known physical or mental disability and or perceived physical or mental disability of an employee. Plaintiff suffered and or was regarded as suffering from a disability and required and requested reasonable accommodation for her disability. Defendants, and again, she wasn't asking for them to modify her working conditions. She was simply asking for time off to get the surgery and recuperate. So again, I don't look at this as a traditional reasonable accommodation request. Defendants in each of them were fully aware of and had knowledge of plaintiff's disability and or perceived disability, and also of plaintiff's request for reasonable accommodation, including time off. Well, what was the rest of it? She didn't say. Notwithstanding this knowledge, defendants failed to reasonably accommodate plaintiff, including but not limited to failing to accommodate her need for time off to have surgery and recover, choosing to terminate her rather than reasonably accommodate her. Defendant's conduct, as described above, constituted a failure to reasonably accommodate plaintiff's known disability and perceived disability. and they're saying that it violates the law. Fifth cause of action, failure to engage in interactive process. Now, I'm going to take a wild guess here. Because of my experience with these types of complaints, state agencies will take a look at it, and clients I represent, I'm required to write up a response or a position statement where you rebut the allegations that the person has made against the business, and you go through and show why what they're alleging either isn't true or why it's not actionable in this particular instance, etc. It may be, given that she didn't file this until many months after this happened, it may be that she did file the complaint, that they did do a preliminary investigation, determined that there wasn't probable cause, and then said, we found no probable cause, but you have a right to sue, which is what normally would happen. And like I said, even if that happens, you still have a right to sue civilly. That's just the agency's not going to take any action against the business. So I'm wondering now whether that's what happened. She asked for them to give her a determination of probable cause, and then she was probably going to sue them. And they said, we don't find probable cause, but you still can sue them because that's your right. So I don't know. That's kind of where I'm leaning in my experience, that maybe that's what happened, and that's why we're going to this lawsuit without having a finding of probable cause from the discrimination agency, which would be a big boost to a civil lawsuit if they found that there was probable cause that the clients discriminated against her. So we'll have to wait and see. Fifth cause of action, failure to engage in interactive process. Pursuant to government code, it's unlawful for an employer to fail to engage in a timely, good faith interactive process with an employee to determine effective, reasonable accommodations for a known physical disability and or perceived physical disability. Plaintiff suffered and or was regarded as suffering from a disability and required and requested reasonable accommodation for her disability. Defendants in each of them were fully aware and had knowledge of plaintiff's disability. And notwithstanding this knowledge, they failed to engage with her in a good faith interactive process to find reasonable accommodation. Rather than discuss reasonable accommodation, they chose to immediately terminate her. Sixth cause of action, failure to take all reasonable steps to prevent or correct discrimination. Pursuant to government code, employers have an obligation to take reasonable steps necessary to prevent discrimination from occurring by their conduct, including but not limited to not training their managers adequately in employee rights to reasonable accommodation and medical leave, and failing to engage in an interactive process with plaintiffs to determine a reasonable accommodation, and terminating plaintiff because of her disability and request for accommodation and protected medical leave. Defendants in each of them and or their agents' employees failed to take all reasonable steps necessary to prevent discrimination from occurring. In engaging in the aforementioned conduct, defendants and each of them aided, abetted, incited, compelled, and or coerced unlawful employment practices in violation of the announced policy of this state against such practices. Seventh cause, retaliation in violation of California paid sick leave law. Now, this is the area that to me is more on target to what she's alleging, is the fact that she asked for time off and allegedly, instead of granting her the time off, they fired her. And again, that something about that doesn't seem right to me. Under Labor Code Section 233, an employer is prohibited from retaliating against an employee for exercising or attempting to exercise their right to use paid sick leave under Labor Code Section 246.5. By their actions as set forth above, defendants violated Sections 233 and 246.5 by retaliating against plaintiff for her attempted use of paid sick leave, including but not limited to by immediately terminating her when she requested a medical leave to have surgery and recover. As a direct and proximate result of the conduct of defendants and their agents, plaintiff has suffered and continues to suffer general damages in an amount according to proof with interest thereon. And again, I'm skipping over some of the language in here because it's not really necessary for you to understand what's going on. Eighth cause of action, wrongful termination in violation of public policy. Plaintiff is informed, believes that thereon alleges that a substantial motivating factor for the adverse employment actions against her was her disability and her request for reasonable accommodation under the Fair Employment Housing Act and her exercise of her rights to medical leave for a serious health condition under the CFRA and sick leave pursuant to California Labor Code. Defendant's retaliation against plaintiff violated well-established fundamental and substantial public policies of the state of California, including CFRA, FEHA, and Labor Code, Section 233 and 246.5. And she says, because of that, she suffered damages, and that'll all be determined at trial. Ninth cause, failure to pay meal and rest period compensation. The code and wage order provide that an employee is entitled to an uninterrupted off-duty meal period, of not less. Now, this is something that comes up. I'm guessing she's possibly be an hourly employee. And basically, what I'm guessing now she's going to allege is that they didn't give her paid meal breaks. The code and the wage order also require the employer to pay the employee 1 hour at the employee's regular rate of compensation for each day that the employer does not provide at least one required meal period. So, and she's saying that in lieu of her having taken a lunch break, because she continued to work through a lunch break, that the law says that they have to actually pay her for that hour she couldn't take her lunch break. The code and the wage order provide that an employee is entitled to an uninterrupted off-duty rest period of not less than 10 minutes for every 4 hours worked or fraction thereof. The code and the wage order also require the employer to pay the employee 1 hour at the employee's regular rate for each day that the employer does not provide at least one required rest period. Plaintiff's initial schedule was 8 to 4, which was later changed to 7 a.m. to 3:30 p.m., 5 days per week. During this time, plaintiff never took either an uninterrupted meal break nor an uninterrupted rest break because she had to remain at the house and because there was not an opportunity to do so given back-to-back tasks and requests of the family. In addition, TFI nevertheless docked plaintiff 30 minutes of pay each day that she worked, despite that plaintiff never had an uninterrupted 30 meal break and despite that she never clocked out from one. So, I mean, did she really have a time clock? This is, I don't know whether she did a time sheet or she actually punched a clock. It would seem kind of weird that she punched a clock at their house. So maybe she did a time sheet and didn't put in for a meal break, but they docked her for it because they assumed she did. I don't know. We'll have to wait and see what the evidence says. So she says that she's owed 2.5 hours of pay on each day or 12.5 hours each week that she worked to defend it. So she never, ever took a break. That sounds a little questionable to me as well. I'm not saying that. I'm sure there were times, because I know there are a lot of times I don't take lunch. Okay, so plaintiff worked for defendants for approximately 3.5 years, 182 weeks, and she's therefore owed approximately 2,200. Oh my God. This sounds a little far-fetched to me, that you're telling me she never once took a break in all of the time she worked for them. That sounds a little suspect to me. Plaintiff's hourly rate at the time of her termination was $30. She's therefore owed approximately $68,250 in reimbursed time and meal rest break penalties. And again, I'll be interested to see what evidence she puts forward to substantiate that. 10th cause of action, failure to pay overtime. The code and the wage order provide that a workday consists of 8 hours, a work week consists of 40 hours, and an employer must compensate an employee who works overtime hours with either 1.5 times or double the employee's regular rate of compensation. The code and the wage order also provide that the employee's regular rate of compensation equals 1/40th of the employee's weekly salary. Defendants employed plaintiff for shifts in excess of 8 hours per day, but failed to properly pay her at the overtime rate for all overtime. Now, they don't quantify this in terms of, they're not saying how many hours they allege she worked overtime or how much it is that she's owed. Something tells me this one's going to be a little hard for them to prove, unless she's got very detailed timesheets that she had turned in that show that she worked overtime and they didn't pay her for it. Again, we have to wait and see what the evidence says. 11th cause of action, failure to pay state and local minimum wage. The code and the wage order provide that an employer must pay a minimum wage to an employee. Plaintiff at times worked before she arrived and after she left work, but was not paid for all such time. She worked before she arrived and after she left? Well, that should be on her timesheet. If your workday started early, you would put on your timesheet that time you started and time you ended, I would presume, but was not paid for all such time. By failing to pay plaintiff for off-the-clock work, defendant violated the labor code. Now, did she do something out of her own volition? It's not really clear here. They don't give a whole lot of information. And again, they're not quantifying this. So it sounds to me like that's probably going to be another one that's going to be hard to prove. 12th cause for failure to pay earned wages. Set forth above, defendants failed to pay plaintiff all the wages she earned as required by the code. So they're saying that the unpaid meal and break time and overtime time is a violation of the act because they didn't pay her those wages. So again, that all depends on what's proven in court. 13th cause of action, failure to furnish timely and accurate wage and hour statements. Code Section 226A required defendants semi-monthly or at the time of each payment of wages to furnish plaintiff an accurate itemized statement in writing showing gross and net wages earned, total hours worked by the employee, rates of pay, and other information. Defendants knowingly and intentionally failed to provide plaintiff with such timely and accurate wage and hour statements, but rather did not reflect plaintiff's actual hours worked. Okay, so I mean this could be true if they're not like using a payroll service. You know how when you get a pay stub, it's got all of that stuff broken down on it. You know, maybe they were writing just a company check to her each week or however often she got paid and didn't go into the details. Although, again, if she is filing like timesheets, she should have a copy of those. So she should know how much time she put in for and be able to figure it out. Although, you know, that doesn't mean they didn't violate the code. But you're also supposed to be shown how much you paid into Social Security and Medicare and all that stuff. So yeah, that would be kind of, especially how big they've gotten, you would think that they would use a payroll service. But again, I don't know if this is accurate because we don't know what the evidence is yet. Under Code Section 226, subsections C and F, and based on defendant's conduct as alleged herein, plaintiff is entitled to $50 for the initial pay period in which the wage and hour statement violation occurred, and $100 per employee for each violation in a subsequent pay period, not exceeding an aggregate penalty of $4,000. So she's saying because they didn't give her an itemized statement, she's entitled to compensation by law. Defendant's conduct also entitles plaintiff to seek preliminary and permanent injunctive relief, including but not limited to in order that they issue wage and hour statements that comply with the code and reasonable attorney's fees and costs. Well, I'm guessing she means to her. 14th cause, waiting time penalties. Labor Code Section 201 and 203 require employers to pay employees all of their earned wages immediately upon discharge. So like when you get terminated, most states have a law that sometimes you have to be given your check that same day, or sometimes it's like within a certain number of days, they have to give you your last paycheck. Under Section 203, if an employer fails to make payment timely, the wages of the employee shall continue as a penalty from the due date thereof at the same rate until paid or until an action therefore is commenced, but the wages shall not continue more than 30 days. Based on the conduct as alleged herein in failing to pay plaintiff all of her earned wages. Oh, okay. She's linking this. She's not saying that she didn't get her last paycheck. She sounds like she's saying that because they didn't pay her all those other things that she's alleging, that now she's entitled to additional compensation because they didn't pay her timely for her work. So it's not that she didn't get her last paycheck. Based on defendant's conduct as alleged herein in failing to pay plaintiff all of her earned wages, defendants must pay a penalty to plaintiff for 30 days wages at a daily rate or not less than $7,200. Further, plaintiff is entitled to reasonable attorney's fees and costs. 15th cause, failure to provide personnel file. Labor Code Section 226 provides that upon an employee's request, employer must provide the employee with his or her wage records within no later than 21 days. Also, most states also have that you're required to, if someone requests a copy of their personnel file, you're requested within a certain amount of time to give them the copy. Failure to so comply subjects the employer to a penalty of $750 pursuant to Section 226F. Labor Code Section 1198.5 similarly requires employers to provide employees' personnel file within 30 days of the employee's request. Failure to comply subjects the employer to a penalty of $750. Beginning in August 2024, plaintiff, through her counsel, requested plaintiff's personnel file and wage records from defendants. Though defendants produced some records, the production appeared incomplete, and over the course of the next several months and repeated requests for time records and signed documents, defendants have failed to date to timely and properly produce plaintiff's complete records, including time records. Plaintiff is entitled to the records requested, to injunctive relief, to statutory penalties, and to reasonable attorney's fees and costs. They gave her some stuff, but not everything. So do they not have time records for her, or did they just not turn them over? I don't know. That all remains to be seen during discovery and going forward. 16th cause of action for unfair competition. Now, this is interesting. I'm be interested to see what they say about this. Defendant's violations of the code and wage order, including defendant's failure to provide plaintiff meal rest breaks, all overtime pay, minimum wage, and accurate wage statements, constitute unfair business practices in violation of the UCL. The UCL prohibits any practices forbidden by law, be they civil or criminal, federal, state, municipal, statutory, regulatory, or court-made. Plaintiff has suffered injury in fact and has lost money or property as a result of defendants' unfair business practices, and defendants have reaped unfair benefits and illegal profits at plaintiff's expense. Plaintiff is entitled to immediate possession of all amounts owed to her by defendants with interest. Defendants' unfair business practices entitle plaintiff to seek preliminary and permanent injunction relief, including but not limited to orders that defendants account for, disgorge, and restore to plaintiff compensation unlawfully withheld from her. Further, plaintiffs entitled to reasonable attorney's fees. Sure of the viability of this 16th cause of action for unfair competition. I don't see where they have set out any argument for unfair competition. It just sounds like they are saying that she's entitled to get all her money right away with interest. And when you allege an unfair business practice, usually there's a consumer law in place. You would make a claim pursuant to whatever the unfair business practice statute is in that state, and you would send like a formal demand to the party you're accusing of unfair business practices, and you would ask for some kind of relief in the form of compensation that you felt you were due. They then would respond to you, and if they don't agree to satisfy your demand, then you can file suit against them. So I'm not quite sure. This is a very weird count. So it doesn't make any sense to me the way I've read it. I'll have to read it again after I finish this. But the way I've read it, it doesn't sound like it's properly couched as a unfair competition. Prayer. Wherefore plaintiff demands judgment against defendants as follows. Compensatory damages in excess of the jurisdictional amount with interest thereon, according to proof. Economic and or non-economic damages. General or non-economic damages for emotional distress. So we've talked about damages for emotional distress. First of all, she doesn't have a count in here for emotional distress, because usually it would be a count in the complaint where you would have a section for emotional distress. She doesn't have one. And again, those are very hard to prove. So given what I've read, I think it's a snowball's chance in hell that she succeeds on that. For all compensation, wages owed to plaintiff, but not paid. For all penalties and or liquidated damages provided under the labor code, for all wages in lieu of rest and meal periods, defendants be ordered to restore to the public all funds acquired by means of any act or practice declared by this court to be unlawful, fraudulent, or to constitute unfair competition, which again, I'm not exactly sure what the heck they're talking about there. Punitive damages, injunctive and declaratory relief, reasonable attorney's fees as allowed, for costs of suit, for prejudgment interest as allowed by law, and for such other relief that the court may deem just and proper, which, as I've told you, is something you, as a standard practice, that's usually the last thing you say, because if the court decides you're entitled to something that you didn't specifically ask for, then you're asking the court to give you whatever that relief might be that they decide that you're entitled to. So that's it. Let me know what you think. So in terms of the reasonable accommodation stuff, in my opinion, from what I'm reading, it doesn't sound like that's going to fly. And that's just my opinion. Based on my experience, I don't think she's got a claim for discrimination in terms of what she's put forward. Wrongful termination, maybe, and all that other stuff about wages, that all sounds more plausible in terms of the suit going forward, for it not getting dismissed out of hand, because I'm sure they'll probably file a motion to dismiss it, saying that there's 12b6 motion, that there's no relief to be granted. And I think by what she's put forward, there's probably enough for the judge to deny that motion and keep this going. But in terms of all that stuff about the discrimination and the reasonable accommodation, I think that's probably not a winner for her, because I don't think that the court's going to find in her favor on all of that. So I'm interested to find out now, what is the deal with all of this wage stuff that she's alleging? And what are the clients going to say is the reason that they let her go? Because I'm guessing in their answer, they may give us a little more information about what their version of the events is. And like I said, whatever you think of Ethan and Hila, from the years that I've been watching them and the stuff that I've learned about them, it just seems weird to me that they would fire somebody for asking for time off for a hernia operation. Maybe that's just me, but that just sounds a little far-fetched to me. There's got to be more to this story that we're not hearing. And that's where the answer and the discovery and everything comes in, that hopefully we'll get a more fleshed out, well-rounded picture of exactly what happened here. But I'll be interested to see what happens. Let me know what you think down in the comments. Please like and subscribe. And Antoinette is here, and she's still purring away. I do have people to thank for the Amazon wish list, but I'm going to save it because I'm doing another video. So I'm going to put all of the Amazon thank yous that I have held aside right now in the next one. So if you sent something, thank you. But I will give you a formal thank you in the very next video, which should be out in a few days. Definitely before the end of the week, because I'm on a schedule where I've got to get a couple more videos out. So, because I do have a new sponsor. So, but I do have 2 videos ready to go that I think you're going to like. So look out for those and look out for the thank yous in that. But thank you to our Patreon patrons again, as always. You guys are amazing. Our channel members, you're amazing. You guys help me to take care of these guys, and I appreciate all the love and support we get from you, all the stuff you guys send the cats, and for your support through Patreon and through the memberships. We really, really appreciate your help. Somebody sent me a donation through PayPal that I forgot in the last video to thank. So if you're watching this video, I'm really sorry. I completely forgot to add that in, but I will also add that to the next video. So thank you guys so much. Take care of yourselves. Look out for that video by the end of the week. But in the interim, take care of yourselves. Love one another. And I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.